introduce themselves and let me know if they are ready to proceed. Mr. Mathe? Mr. Mathe, you are on mute. Can you unmute your speaker, please?
Sorry, my lady. It's Mjaju Joseph Mathe for the applicant himself, and I'm ready to proceed, my lady.
Thank you, Mr. Mathe. And for the respondent?
May it please the court, my lady, I confirm my appearance on behalf of the respondent. It's Libbe, initials L, from the Pretoria Bar.
Thank you, Ms. Libbe. Okay. As I said, prior to this matter being, or when this matter was set down for this hearing, I received and what was uploaded onto case lines on the court file by the applicant. Let me just get to, is a document that is headed application for recusal in the Rule 30A application. Now, Mr. Mathe, I've considered this document and I've had a look at it, and I've considered what you've said there in respect of you will not depose to an affidavit to support your recusal application, but will make oral submissions at the hearing of the application to strike out and the leave to appeal. Now, I know that you're a layperson, however, you have a certain grasp of the legal language and the rules of this court, as you have demonstrated in the main application. So you're not oblivious to the rules of the court. This document is not a notice of motion in any form, long form or short form. There's no affidavit containing evidence or facts upon which you base your application for recusal. All this court is presented with is a document titled Application for Recusal and an acknowledgement that no affidavit with supporting evidence will be filed and that submissions will be made at the hearing. Now, Mr. Mathe, as you are aware, in motion court, evidence is led by way of affidavits which are sworn as the truth and the contents there are. Evidence is not led from the bench. The bench makes submissions in support of the evidence that has been led. So in that respect, whilst there are cases where an interlocutory application need only be supported by a notice of motion without an affidavit, it has to at least be supported by a notice of motion. And Rule 6.1 of the Uniform Rules of Court make it clear that the standard by which applications are heard and proceedings, all proceedings, save where proceedings are by way of petition, are prescribed by law. Every application must be brought on notice of motion supported by an affidavit as to the facts upon which the applicant relies for relief. This is not the case in this particular document. It is a document that does not conform to any of the standards of a notice of motion, be it a long form or a short form. It is not supported by an affidavit. And it's important because in a recusal application, the key principle is that the party seeking a recusal must demonstrate a reasonable apprehension of bias, supported by objective facts rather than subjective beliefs or perceptions. And that is a key principle that was confirmed in the recent 2025 case of Boyson versus Kimberley Regional Court Magistrate for the Northern Cape and another, that's ZANCHC 114. Having regard to that key principle, a recusal application is normally supported by an affidavit with the evidence that demonstrates this reasonable apprehension of bias. It cannot simply be brought by a piece of paper filed. And this principle, to demonstrate this principle, an affidavit is required. In the recent Constitutional Court case of Zondo versus S, and that's Zondo versus S 2025 ZAG PPHC 377, the Constitutional Court heard the recusal application, which was brought by notice of motion and accompanied by a founding affidavit, which the court treated as a norm in such recusal applications. Now, in this particular matter, and in the circumstances where there is no notice of motion, but a document containing grounds for recusal, and an acknowledgement that no affidavit will be filed, and there is no affidavit to even support the application, I find that the applicant has not brought a recusal application in terms of the rules of the Uniform Court, and therefore there is no recusal application requiring determination by myself. And that is my order. Now, having said that, there remain 2 applications before this court, and I now direct my response to the respondent, to Ms. Leber, that there is a Rule 30 application. In effect, it is a point in limine that the notice of appeal was filed out of time. I have read the Rule 30A application, but what I have failed to see, Ms. Leber, is where the prejudice has been suffered by the respondent. There's no allegation in the affidavit as to prejudice. And my understanding of Rule 30A and of any point in limine to seek to show that a application is out of time, there has to be some sort of demonstrable prejudice suffered by the respondent. So I would like you to briefly just answer me this. Is there any need to argue then the Rule 30A application, as we all hear and we're ready to proceed with the application for leave to appeal? And insofar as I do not find that there's any prejudice, can you please respond to that?
May it please the court, my lady. My lady, given the court's view of the Rule 30A application, and the respondent would seek finality in the matter, the Rule 30A application, we concede that it need not be argued. I don't know whether the applicant wishes for it to be argued, but we can proceed directly into the leave to appeal and the merits thereof in order to dispose of the matter.
Thank you. And are you, as there was no response by the applicant, the respondent to the Rule 30A, my view here, and I'll ask Mr. Mathe to address me on this, is that condonation insofar as the notice of appeal has been filed late is granted with no order as to costs.
As it pleases the court, my lady.
Mr. Mathe, what is your response to that submission or proposal?
My lady, I disagree, my lady, that the Rule 30 application is a point in limine. It was actually an interlocutory application that was never set down. When they said it, I asked them to set it down, and they never set it down, my lady. So it's not like they are. But if, my lady, they abandon the Rule 30 application and we go to the leave to appeal straight, and there are no costs, no problem, my lady, because I didn't even prepare for the Rule 30.
Thank you, Mr. Mathe. So insofar, I make the following ruling in respect of this Rule 30A application. Insofar as the notice of appeal may have been filed late, such late filing is condoned by this court, and there is no order as to costs in the Rule 30A application. Thank you. So we can then proceed on to the application for leave to appeal. Just to familiarize everyone with how it will proceed, insofar as Mr. Mathe is a layperson. Mr. Mathe, you will start, the respondent will answer, and you will have a right of reply. Please ensure in your argument that when you address me on the cost of this application. Mr. Mathe, you may proceed. Ms. Leber, you may turn off your camera while Mr. Mathe is addressing the court.
As
Thank
pleases.
you.
Yeah, okay, thank you, my lady. My lady, I will start with the grounds and then finish with the costs. My lady, I would like to. My first ground is. Sorry, my lady, give me a second. Okay, where is this now? Okay, yes. My lady, this leave to appeal, my lady, has to do with the simple fact, the pleaded case, my lady. My lady, the pleaded case is damages, my lady. And you can see from the notice of motion that the applicant pleaded damages. And this was argued, submissions were made on this point extensively at the hearing and on the heads of argument that were submitted, that the applicant seeks damages for loss of income. And my lady, the difference between loss of income and compensation is there, in the pleading. I even provided the test to prove the loss of income and not compensation. But the first thing that the judgment says is it says that the applicant here in this court now seeks compensation. I never sought compensation, my lady, and this is it's not clear where the court made that finding, because the court is bound by the notice of motion, and if the court on the first step, it says it gets the relief wrong, the entire judgment is wrong. As a result, the judgment, my lady, I submit that is written on a false premise. As a result, anything from it is unsustainable because the relief is wrong and the court cannot give a relief that was not asked for. I was specific in what I asked for, but the court misconstrued the relief sought. And my lady, the other part is that there are things that the applicant deposed 2 affidavits in the main application, and in those 2 affidavits, there is no place where the applicant says anything about the CCMA that the dismissal was fair and whatnot. That was never said by the applicant, but the judgment says the applicant did say that his dismissal was fair. The applicant never said that, and there's no evidence of that. So it's also not clear to the applicant where the court got that finding. And my lady, the judgment simply, in addition to ignoring the pleaded case that it is bound to resolve, the court also ignores the statute pleaded. The applicants pleaded the basic conditions of employment act, my lady, and then that statute is the judgment ignores it entirely. It's not cited, nothing is said about it. So it's proper to say that it was not the case pleaded was ignored, and the statute cited was ignored. And then the third part about is jurisdiction, my lady. The court made a misdirection of law and fact. It said it incorrectly accepted jurisdiction, that yes, this court has jurisdiction, but that jurisdiction was incorrect because it was not the jurisdiction pleaded by the applicant, my lady. And my lady, the court has multiple. Sorry?
Sorry, that might have been someone else just entering the room by mistake. I'll turn my mic off. My apologies, Mr. Mathe.
Okay, so my lady, the court has multiple jurisdiction, monetary jurisdiction, aerial jurisdiction, and all of that. But what is important is that the court is bound by the jurisdiction pleaded. I did not plead monetary jurisdiction. I pleaded the statutory jurisdiction, which is Section 77 of the Act. But the Act ignored that, and so far, what my submissions are is that the judgment ignores the pleaded case. It also ignores the statute pleaded in its entirety. And my lady, this is an infringement of the applicant's constitutional right, because the constitutional right states that when the court interprets legislation in the matter, the legislation was the Act, the Basic Conditions of Employment Act, and it was ignored entirely. But it was, and the court made a huge misdirection by not doing that. So it's the pleaded case, and the jurisdiction is also incorrect, my lady. The court misdirected itself and took accepted jurisdiction that was not pleaded. And then the third ground is the misapplication of the Plascon-Evans rules, my lady. So the Plascon-Evans rules, and my lady, since the judgment ignored the basic conditions of employment, the judgment went straight too far, because, my lady, when a matter is a label matter, they change the rule. The application of the Plascon-Evans rule is not just applied in the general sense; it's applied robustly, so that those disputes are resolved. So when, upon reading the judgment, it's clear that the judgment simply says that there's a dispute of fact, more particularly to the oral contract. But, my lady, I would like to submit that the oral contract, it does not have a life of its own. It's dependent to the written contract. So the correct thing is to start with the pleaded case and say, okay, this is the pleaded case. What are the disputes? What are the disputes that cannot be resolved? And the court even failed to identify the disputes that factual disputes, because upon reading the judgment, the applicant could not objectively identify the factual dispute, because what was the main thing was the contract itself. If the contract is not in dispute, the written contract is a secondary fact. The written contract is a primary fact. If there is a breach of contract, the contract is breached, and then the court can then go further and then say, okay, the written contract is breached, and then look at the written, the verbal contract. And the verbal contract, my lady, it does not even, contracts don't need to be written in order for them to be enforced or for damages to be awarded, because a contract can be one can infer that there was a contract based on conduct. The respondent and the applicant made this submission that the respondent has performed, and in their answering affidavit, they did not rebut that they performed. So, my lady, even that, my lady, is a misdirection, because the respondent did not dispute that they performed in terms of the oral contract. And then, my lady, and then there is an issue of cost, my lady. The costs were also awarded based on the wrong principle, my lady, because, my lady, the respondent did not file, the respondent did not, they sent their affidavit with no attachments. And then on my replying affidavit, I did say that I did not receive those attachments. And then before the hearing, those documents, even though they were not filed, they were put on case lines. And then and then that was improper. And I've noticed that the judgment did rely on those. I suspect the judgment did rely on those documents that were not filed. And then after the hearing, my lady, the court did not ask for heads of arguments to be submitted, but after the hearing, the respondent filed heads of argument without leave and without informing the applicant, my lady. And that, my lady, is unfair. Even if the respondent were entitled to cost, but because, my lady, they did not conduct themselves fairly and transparently
Sorry,
with the
Mr. Mathe. Where in the application for leave to appeal is this ground? This is the first time I'm
ground
hearing
of court.
this.
The ground of the court.
These allegations that you're making, that the respondent improperly uploaded documents.
Okay, my lady. My lady, I would like to say this. That part, when I was drafting the leave to appeal, I forgot to add it. So if the court does,
Okay,
doesn't
Mr. Mathe, yeah, I can't consider that because the other party hasn't had an opportunity to consider that. And we are limited to what you have put down in your application for leave to appeal. Thank you. You may proceed.
Oh, sorry, my lady, and the court did not engage with all the submissions made by the applicant, written submissions and oral submissions that were made. So, my lady, it's also unfair because even the pleaded case was not engaged, even everything the applicant did was not engaged, and all the findings the court made were not supported by any evidence that was put before the court, my lady. And yes, my lady, I think I've covered everything there.
Thank you, Mr. Mathe. You'll have an opportunity to reply to Ms. Lebbe, but Ms. Lebbe, can you please answer?
I please the court, my lady. My lady, just briefly on the answering affidavit and the heads of argument, although we did not prepare on it and the court is not considering it, I just wish to point out to you, ladyship, if your ladyship have regard to case lines, on the left-hand side where the drop-down is indicated, the answering affidavit was filed on the 31st of May, if your ladyship look at section 26. And all the annexes are there. So that in any event has no merit. But that's just on a side note. My lady, I will deal with the grounds of the appeal as they are listed. The first one is the mischaracterization of the relief sought. Now, while it might be true that in your ladyship judgment it started out to state in paragraph 1, before this court is an application in which the applicant seek compensation. Your ladyship would have recalled that during argument in the main application, the applicant, during his whole argument, either referred to damages and compensation on various occasions, and the court on numerous occasions asked the applicant to clarify the relief. But the mere naming of compensation, your ladyship, it was not misdirected. Because if your ladyship look at page 5 of the judgment, your ladyship has dealt there with the breach of the contractual claim and at paragraph 16 with the damages sought and whether relief was made out for the damages. So I would submit that that point falls flat on insofar as there might be merit in. Your ladyship would also note from the notice of motion. Now there's two. One is the amended notice of motion on page 02. Apologies, my lady, my printed version does not have the case lines reference cut off at 02-82. From the amended notice of motion, prior 1 indicate the respondent is ordered to pay the applicant damages in the amount of 140,874 and 12 cents, which is equivalent to 12 months' salary. Now, that was also debated during the main application. But insofar as he sets out his claim, your ladyship would see from 02-8 in the application. He indicates there that he signed the contract under duress. Then he goes further to state, well, clause 15 states that the applicant was employed as a lab technician and not an inspecting technician. The respondent made changes to the employment contract of the applicant. The said changes fall in section 29(1)(b) of the Act and were not in writing, and the applicant did not consent to any change. Nowhere it stated what type of change occurred or what is the breach of contract. But be that as it may, furthermore, he indicates later on that page at paragraph 26 that there is on the 1st of February 2021, the respondent had a verbal contract. So on the applicant's own version, there is a written contract and an oral agreement, which is denied, and that goes to the dispute of fact. But then he goes on in his replying affidavit at page 02-72 to plead his cause of action. The ladyship would see from paragraph 37 at the top of the page.
Sorry,
Says-
what? 002 dash
72.
and 72. Okay,
Yes,
thank
my
you.
lady. It's part of the applicant's replying affidavit. He sets out his cause of action as follows, and your ladyship could read the second line from the top, the third sentence. This is a different cause of action. There are two causes of action that stems from dismissal, illegality and fairness. The Labour Court has exclusive jurisdiction in regards to fairness. However, the High Court and the Labour Court enjoy concurrent jurisdiction where it comes to illegality or unlawfulness. The applicant submits he exercising the concurrent jurisdiction. Now, that is as far as the applicant, or the closest the applicant comes to plead a cause of action, which is also no cause of action, my lady. And I'll get to the cause of action and the way it's pleaded a bit later on. Then the second point my learned friend made, or the applicant made, is the inconsistent findings on jurisdiction. Now, as part of the answering affidavit, and as a point in limine, there was a lis pendens point raised regarding the court's jurisdiction. And the ground of appeal reads that the judgment acknowledged that the High Court has jurisdiction, but simultaneously criticized the applicant for forum shopping. These findings are contradictory. If the court accepted jurisdiction, it cannot in the same breath penalize the applicant for exercising that jurisdiction. This internal inconsistency reflects a failure to properly engage with the legal test for concurrent jurisdiction between the High Court and the Labour Court and the right to access of court. Now, my lady, your ladyship dismissed the point of lis pendens, and in your ladyship judgment, at paragraph 7, your ladyship found that the applicant's contractual claim for breach of contract is legally distinct from this unfair dismissal claim in the CCMA Labour Court. Different causes of action are involved, even though they are arising from the same factual matrix. Your ladyship dismissed our point in limine, and your ladyship correctly found that this court has jurisdiction, although concurrent, and that there's two different causes of action. So the point also is meritless, as your ladyship already found in favor of the applicant in that regard. Then the lack of engagement with the constitution and statutory grounds. My lady, he makes mention that the claim is not a private law claim, but a public law claim, also a public law claim. Now, this is nowhere in the founding affidavit, nowhere in the answering affidavit, nowhere in the replying affidavit, and nowhere in the applicant's head of argument during the main application or now. This ground of appeal is an afterthought, which is now all of a sudden an issue, and that is something that your ladyship did not consider. But it was never placed before the court, so the court could have never considered it. But be that as it may, in the founding affidavit, and so far as there might be the attempt to claim based on contractual, I have set out in my heads of argument the difference between public law and private law. And I do submit that the contractual claim falls squarely within the private law. And in paragraph 79 of my heads of argument, I have set out the definition of private law and what constitutes private law as set out by Tracy Hamley in the Introduction of Law and Legal Skills. And that includes the conclusion of a contract and a claim compensation from one another because of a wrongful act. So public law does not speak to this matter at all, and it's not applicable. Insofar as the labor relationship or the basic conditions of employment is, it was quoted various times in the founding affidavit on the sections that is reliant on. However, that section speaks to discrimination. It does not speak to contract at all. So that point also falls without merit, my lady. Then the next point is that your ladyship erred in paragraph 10.1 of the judgment. If I can just get there, my lady. Paragraph 10.1 of your ladyship's judgment, it's inconsistent versions by the applicant in the CCMA proceedings, the applicant indicating that the dismissal was procedurally and substantially fair, but claimed discrimination. In this application, he alleged the dismissal was unlawful. If I can direct your ladyship, and this is part of the review record at page or section 26-46. 48, apologies, my lady. So in his founding affidavit, he claims that the respondent is in breach of contract, and then he claims damages which no one knows how it's been computed. But in or on page section 26-48, it is the applicant's examination in chief under oath. He indicated he was not guilty of the charges at paragraph 4.21. He indicated he was not guilty of the charges, but during his explanation, he admitted some of the jobs was done incorrectly. So there he admits he's actually the one in breach of contract. And it goes on. Paragraph 4.24. He agreed that was wrong. 4.25. He stated
Sorry, sorry, I'm lost. I can see the document you are referring to.
So you would find that as part of the respondent's answering affidavit on case lines. You will see at the left-hand side, there's section titles or section names. It reads respondent answering affidavit and annexes. Do you see that?
Sorry, I don't see any.
Mr. Mathe, Mr. Mathe, you need to go to case lines 26-48. 26-48.
Wait, give me a second. On the respondent's answering affidavit, right?
Yes. So if you go to view, find, and you click on find page, type in there 26-48, and it should take you to the page.
My lady, I'm not finding it.
Have you got?
No, not yet.
26. Have you got a heading called 26 : respondents answering affidavit and annexures on case lines?
No, I do not, my lady. It's under which heading?
It's heading number 26. Respondents answering affidavit and annexures.
My lady, I do not have that on case lines. It's not available here on case lines, on my case lines. I'm on case lines, and the document only ends with section 20 with the final stamped order, which is section 22. There's no 26 on my case lines.
There should be a section 25 and a section 26. It's been there since the 31st of May.
My lady, perhaps I can assist the applicant and just share my screen. Perhaps he can then view it on my, or I can show my case lines to him that he can follow.
Yes, please do that.
Thank you. Thank you, Ms. Lubber.
Is my case lines page visible?
It is visible.
Yes, it is.
Mr. Mathe, can you see it?
Yes, I can see it.
So you will see we are here on the page. My mouse
can I object? Or I'll have my chance, my lady.
What are you objecting to, Mr. Mathe?
My lady, this document, on case line. This document was not filed. It was removed from case lines. That's why when I go to case lines, it's not there, my lady, because it was not filed with the court. And there's no.
No, Mr. Mathe. Mr. Mathe, I'm live on case lines right now, and I'm looking at the document. I'm not sure if you've downloaded a documents and you're not live online. I suspect that might be the issue, but that I'm not prepared to hear your objection because it has no merit, because I am looking at case lines and I can see the document. It is online and it has been there since the 31st of May.
Okay, my lady, no problem.
Thank you. Please proceed, Ms. Lubber.
As it pleases the court, my lady. So as I was indicating, on page 5, he stated that the lenses were one transition lens and one that wasn't. He stated one lens changed color and the other did not. And so on it goes and it goes. Paragraph 27, he furthermore admitted that he missed the lenses. He passed it to quality control. Page 7, he agreed he was wrong. So in all of that, he admits that he's wrong. And if one looks at the contract of employment, that is Annexure R5 to the founding affidavit, and your ladyship would find that it starts at 02-12. And as part of the contract of employment, it includes at paragraph 2.4 on 02-13, the employee's capability and competence to perform the duties and or services in the terms of this contract is warranted by the employee who declares having the necessary skills and knowledge. And then it goes on to state in paragraph 2.5 that the employee accepts the requirement to work the normal standards of productivity as set by the company. So actually, my lady, this demonstrates that it is the applicant who is in breach of contract and not the respondent. But your ladyship would have also noted from the founding affidavit, he makes the allegation that one of the grounds for breach of contract was that he was not paid for overtime work. And then he contradicts himself in the very same paragraph on 02-8 at paragraph 26 of the affidavit. He states that he had a verbal contract. The applicant would work the third shift and received a night shift allowance. The applicant asked for a written contract of the night shift. Herein marked as Annexure FF6 is proof thereof. It was never submitted to the applicant. However, the respondent performed in regards to the verbal contract by paying the applicant 2,800 for working the night shift. So, my lady, on his own contradictory version, he alleged that there was breach because he wasn't paid, but then he alleged that he was paid. And in the payslip also annexed to the founding affidavit, it's also indicated, or in the payslip, your ladyship would see these two. I can just get there. These two lines on page 02-27. So his payslip starts with basic pay and then night shift allowance. The ladyship would see the night shift allowance is 630 rand, and then the next line is overtime at 2.0. Then that is 928 rand and 90 cents. So he was paid. But even if your ladyship has regard to 26-75, and that is his grounds for the review in the Labour Court. He indicates there, it's in the middle of the page, about 5 lines down. I was excluded from working overtime from February to October 2022. So, my lady, there's also no breach of contract there. It's a mere allegation that he couldn't work, but then he alleges he wasn't paid, but he was paid. So that argument also falls flat, my lady. And there's no merit that your ladyship erred in paragraph 10.1 of the judgment. Then the next ground for appeal is that the court misdirected itself in focusing on the verbal contract, which was secondary to the written contract. Now, your ladyship would have noted he made the allegations in the founding affidavit that there was a verbal contract, and the verbal contract was breached, and he never received the verbal contract. However, if your ladyship look at the written contract, and the oral agreement is denied by the respondents in the answering affidavit, as there was never a verbal contract. Now, in the contract of employment, there is also at paragraph 5.4 on page 02-15, indicates there the employee may be required to work shifts as and when required by the company. And then paragraph 5.1 above states that the employee agrees to work additional hours from time to time due to operational requirements during week, over weekends, and or during public holiday, on request of the company and subject to reasonable notice where possible. So in any event, in the event that overtime has to or had to be worked, it was already included in the written contract. It was not a new contract or a new oral agreement. It was always part of the written contract. Hence, the oral agreement is in dispute. But furthermore, the oral contract has no clauses or terms of the oral agreement pleaded herein. So one is left to guess what case we need to meet, or what the terms of the oral agreement was, or what terms was even breached, because there's no allegations in the founding affidavit or the replying affidavit. So, my lady, I do submit that this point 2 has no prospect of success. Then the next point of appeal is the court erred in finding that the applicant made sweeping statements. My lady, it is submitted, and with respect to the applicant, there is various sweeping statements in his founding affidavit as well as his replying affidavit. I have already referred your ladyship to a few of the sweeping statements. And as but one example is that he was employed as a lab technician and not an inspecting technician. The respondent made changes to the employment contract of the applicant. The said changes fall within section 29(1)(b) of the basic conditions of employment. Clearly states that they must consent and it must be in writing and both parties sign. This is an infringement of both the contract and conditions of employment. My lady, that statement is a sweeping statement. There's no quantification or no explanation as to what went wrong or what. It's mere just a statement to skip some sort of atmosphere for the applicant's claim. And it goes further that he says he won't give all the evidence in his founding affidavit because he will be embarrassed and he will make submissions to the court. And it goes on and on and on. And then in paragraph 11 to 16, he merely states sections in the Act. My lady, that is no cause of action and there's no merit in that. It's also just sweeping statements. So your ladyship correctly found that he made various sweeping statements and the court did not err in that regard. And the next point or ground of appeal is the court did not dispose of the real issues between the parties. Now, my lady would have recalled that during the argument in the main application, your ladyship at various times stopped the applicant to explain what is the relief being sought. And your ladyship also asked him to explain what is the relief sought in the Labour Court or in the CCMA, then the review and so forth. So your ladyship during the arguments dealt with the merits of the matter and engaged with both the applicant as well as the respondent. And from your ladyship judgment, it is clear that your ladyship considered the real issue. Your ladyship dealt with the point lis pendens that was raised by the respondent. That is in paragraph 3 to 7 of your ladyship judgment. That was one of the disputes regarding the jurisdiction of the court. And your ladyship has dealt with that, and your ladyship correctly found that this court also has concurrent jurisdiction to entertain the claim insofar as there might be a claim. Then the second point of in limine, the material dispute of fact. Now that was also argued during the main argument, and your ladyship has dealt therewith in paragraph 8 to 12 of your ladyship judgment. So again, your ladyship dealt with the disputes. And then on the merits, as this is a purported application based on breach of contract, your ladyship also dealt with it in your judgment in paragraphs 13 to 18 thereof. Your ladyship dealt with all the requirements that the applicant has to meet, and that after that, your ladyship dealt with each and every requirement of breach of contract. So your ladyship also dealt with the dispute. The main dispute is the damages claim based on contract, insofar as there might be one. So it's respectfully submitted. The court did not err in that regard, and your ladyship dealt with the real disputes in your ladyship's judgment. Then the next point is the court erred in finding of the factual dispute. My lady, again, he makes mention of an oral agreement, which is denied. The only way to prove an oral agreement is by leading the evidence of the parties who entered into the oral agreement. So that is one of the main disputes, my lady. And then there's also further disputes and contradictory versions. Your ladyship would have also recalled from the argument, and your ladyship was referred to the CCMA and the review application. And there a complete different version of the events is set out under oath and the evidence given during the arbitration. And this founding affidavit directly contradicts the other version, which is also under oath. So that must also be, by way of evidence, be resolved and be questions and cross-examination. And I've also directed your ladyship's attention to the judgment that was uploaded under section 20, the Greiling versus George Randall High School, that was uploaded under section 21 to 20-22. And that judgment similarly also held that in the event that there is a dispute of contract and the terms thereof, one cannot, by way of application, bring an application to court. One must proceed by action. And in that case of Greiling, the court dismissed the application. And your ladyship was also correct in dismissing the application, as there's simply too much factual dispute, which the applicant was well aware of, since his disciplinary hearing, throughout the whole review proceedings, as well as this application. So he would have foreseen that there would be a factual dispute. Then the next point, my lady, is the quantification of the damages. Now, my lady is claiming 12 months salary in the amount of 140,000. And if I can direct your ladyship to the offer of employment. Apologies, my lady, I'm just looking for the annexure. On page 02-25. Now that is the letter of employment, and the basic salary is set out there as 8,186 rand and 36 cents. If that is multiplied by 12, one gets to an amount of 98,236 rands and 32 cents. That is nowhere close to 140,000. So even if one will use that to calculate or an attempt to ascertain what the quantification of the damages is, it does not amount to 140,000 as per the notice of motion. And in the founding affidavit, the only paragraph that dealt with the quantification of the damages insofar as he might claim damages is paragraph 33 in the conclusion at 02-10. The applicant prays for a maximum of 12 months salary because of the multiple breaches of the basic conditions of employment, provisions, and a number of breaches of his employment, all of which resulted in his illegal termination. The rest of the founding affidavit, as well as the replying affidavit, is totally silent in as to how the amount was calculated, why the amount was calculated, or what type or formula, or how did he get to the amount that he's seeking, my lady. So there is no quantification of the damages, and this ground too has no ground or no prospects of success. There's also no evidence presented by the applicant, and he miserably failed to prove his quantification and the damages. So, my lady, the court did not err in finding that there is no quantification of the damages. Then the second last ground, the third last ground, is the test for damages for loss of income. Now, the applicant relied on that the court erred in applying the test for damages as set out in Mjaju, apologies for the pronunciation, versus RAB. Now, there's no citation, but the case that I found, and I presume that is the case that the applicant is reliant on, is the 2012 Gauteng Division High Court judgment of 17 April 2012, wherein there was damages sought, but it was patrimonial damages due to a motor vehicle collision. And that case, with respect, is not applicable. This breach of contract is a contractual claim, and your ladyship, in order to prove a contractual claim, and as set out by Ambler's on page 114, is a party must prove a contract, the breach of the contract, damages, a causal link between the breach and the damages, that the loss was not too remote, that depends on whether the damages are general or special. Now, my lady, this is for breach of contract. And in the Mjaju matter, it's based on the DILEC. There's separate requirements. In a DILEC, your ladyship will be well aware that one must prove conduct, wrongfulness, fault, causation, and harm. That is also not set out. And as that case is not applicable, your ladyship correctly did not consider it. And accordingly, this ground has also no prospects of success. Then the second last ground is the restitutio in integrum. My lady, this again is nowhere in the founding affidavit and the replying affidavit. And as an afterthought, it has been inserted as a ground of appeal. So from the outset, this ground has no merit, as this was never before the court in the main application. But insofar as he might rely on this principle, and I've inserted the definition thereof in my heads of argument at paragraph 106. To rely on this principle is that parties would be placed in the position had the contract never been entered into. Now, my lady, if this was the claim of the applicant against the respondent, the applicant would have made sure, or the applicant would have been placed by his previous employer. That is something that the respondent cannot guarantee. The respondent cannot ensure that the contract with the previous employer is entered into. And this was never in the founding affidavit or applying affidavit. And this principle or this relief or cause of action is also not applicable, my lady. And this also does not speak to the claim of damages, because if the contract was never entered into and you want to go to the position before the contract was entered into, there's also no claim for damages. Then the last ground of appeal is that the court failed to consider the evidence, the heads of argument, and oral submissions. My lady, this with respect also has no prospect of success. During the argument, your ladyship was referred to by the applicant, as he argued first, to his founding affidavit, the annexes thereof, various cases, and even Ms. Mongwane, which was sitting in the other matter, assisted the applicant in referring to some of the cases and the citation of the cases. And your ladyship took extensive notes during argument. Your ladyship also interacted with both the applicant and the respondent during argument. During argument on behalf of the respondent, your ladyship was also directed to various portions of the affidavit, as well as the annexes, the heads of argument, the cases referred to in the heads of argument, my lady. So I submit that this also has no prospects of success. It is completely meritless, my lady. My lady, and then lastly, in light of all the above submissions, it is submitted that there's no compelling reason why leave to appeal ought to be granted. The applicant miserably failed to show that another court would come to a different conclusion or to a different decision. And the test is quite strict, my lady. And the applicant, unfortunately, did not meet the requirement that another court would come to a different conclusion. I submit that this application, and in light of the respondents, and I've started at the beginning of my heads of argument, in his practice note, your ladyship would have noted that he said there he will prosecute an appeal despite the merits thereof in order to frustrate the execution. My lady, so I submit that this application is nothing but vexatious and a meritless appeal in an attempt to frustrate the respondent further. Your ladyship would find that in paragraph 21-1 of the practice note, that is on page 03-5, it states, to preserve judicial resources and uphold the principle of finality in litigation, the applicant requests that the court simply endorse the draft order. The respondent will in any event request written reasons, even if delivered at the hearing. Granting a draft order will avoid the waste of time associated with preparing a written judgment in circumstances where the appeal will be prosecuted, irrespective of merit, with the singular aim of frustrating the enforcement. My lady, the only portion of your ladyship's judgment that the respondent can enforce is by taxation of the cost already awarded, my lady. And that's the only aspect that the respondent is busy frustrating. And now is prosecuting a meritless appeal, forcing the respondent to incur more unnecessary costs. And my lady, he will most probably, given his stance in paragraph 21.2 of his practice note, will file a leave to appeal to the Supreme Court of Appeal that we will also have to defend should the Supreme Court of Appeal accept this. As he indicated, he will just frustrate the process, my lady. And if I can also direct your ladyship's attention to page 02-17, that is part of the replying affidavit. And here he makes the allegation completely unfounded, without any evidence, completely vexatious. Should the presiding judge of this matter be found wanting, he will be given gratification by the respondent. The respondent have a history of giving gratification to judicial officers as defined in the Combating and Prevention of Corrupt Activities Act. My lady, this applicant is insulting the integrity of the respondent, but not only of the respondent, of this court as well. And your ladyship would have noted from the matter of public prosecutor versus the South African Revenue Services, paragraph 6 and 36 of that judgment, the court held that attorney and client costs is warranted in order to instill respect to the court and to deter wholly unacceptable behavior. My lady, the applicant has demonstrated he will prosecute applications without merits, and he will ensure that he will commit crimes against humanity if the court does not find in his favor. Your ladyship would find that also in the replying affidavit in paragraph 95 of 02-77. He goes so far, the applicant humbly submits that there is no part of this application that gives him any pleasure. The court should remember that Adolf Hitler was refused entry at the prestigious art school, and he committed the worst aristocracies against humanity. As a result, should the applicant not continue with his studies at Wits and be beat by his white peers to the market and watch them change the world while he is in poverty, there is no telling what the applicant will do. He will lose his faith in the Constitution and is very likely to commit aristocracies against humanity and hate crimes. The court should never underestimate what happens when a young man is denied the opportunity to make his dream a reality. My lady, given the stance of the applicant, I would submit that your ladyship should dismiss this application for leave to appeal, would cost on an attorney and client scale, my lady, in order to instill respect for this court and to deter the applicant's wholly unacceptable behavior. My lady, that's the submissions on behalf of the respondent. If your ladyship has any other questions, I will gladly answer that or address that as well.
Thank you, Ms. Libber. I have no further questions, and I have got your heads of argument. Mr. Mathe, can you please reply?
Yes, my lady. I'd like to reply. My lady, a leave to appeal is not to re-argue the merits. I see the respondent re-argued what they've already argued. My lady, at the hearing, my lady, you will remember that you asked me how I quantified the damages, my lady, and I did say that the amount is there on paragraph 23 of the founding affidavit is there. When you multiply it by 12, and then you take the amount from the written contract and you multiply it by 12, the math checks out there, my lady. And my lady, I did make this submission also that I wanted a declaration from the court, and my lady, the court did not engage that point in its judgment, my lady, and as such, it's a judgment in a vacuum. And my lady, the second part I would like to put to your attention, my lady, is that if just because something is on case line, it does not mean it's before the court. So, my lady, the part where you were directed to what is alleged to be my founding affidavit, it's not. What they told you that I admitted to, and I did clarify this at the hearing, was a report by Esther de Beer. And my lady, that's not me. She said I admitted things, and that's not under oath as well, my lady. So, my lady, for now, maybe when you will consider those things before the court. But my lady, on appeal, my lady, when I construct the record, those things that do not bear the court stamp won't make it through the record, and the case will change. The court will reach a different conclusion. And my lady, the second part is that, my lady, there are things that I said on the pleadings there that I attributed to the respondent's conduct, but the respondent is attributing them to me now. My lady, the first part is that the test is whether another court will reach a different conclusion, my lady, and based on my grounds, it will reach a different conclusion, my lady, because the court decision is a non-decision. And my lady, when if you check on the replying affidavit where I say the court should just grant, on the practice note where I say the court must sign the draft orders because the respondent will appear. I said the respondent would appeal irregardless, but now at this court it is said that I said that whatever the outcome, I will appeal, my lady. So, my lady, I don't think that's fair. And the second part, my lady, is that I filed heads of arguments there on court online there. They were ignored, and on my heads there, it's explained that how the damages are calculated, and the court ignores that. And even now, my lady, I'm bringing it to the court's attention that the document the respondent is referring to is not on case line. So, my lady, can I go to case line and show you that it's not there and share the screen like the respondent did?
No, Mr. Mathe, I'm working on case lines. I'm not working on court online. I'm working on the documents that have been uploaded onto case lines.
Yes, my lady.
A hearing is not done with court online. The practice directives are very clear that for a hearing to take place, the documents must be on case lines. Okay.
Sorry, my lady. Yes, my lady. I mean, can I go to case lines and show you what I'm talking about? Can I also share my screen and show you as well, as the respondent did?
You're welcome to, Mr. Mathe.
Oh my God, it's not working, is it? Sorry, my lady. It turns out I can't really share it.
That's fine. Mr. Mathe, the issue is that those documents were before me in the main application and were dealt with. I'm I'm not sure why your case lines is not reflecting them now. But according to the stamps that are on case lines, they've been there since 31 May. So I don't think there's any merit in persisting with that discussion.
Okay, my lady, yes, my lady, you when the respondent was showing you the document, did you identify the court stamp on that document? If you did,
No,
then
Mr.
it's
Mathe,
right.
that is not my job.
Okay.
That is not what I've been asked to do. Thank you.
Okay. Yes, so no problem, man. Yes, I have nothing further, my lady.
Mr. Mathe, Ms. Lover raised an argument that this application should be dismissed with costs on an attorney and client scale. As you're aware, that's a higher scale than the normal scale. Please just address me on that issue.
My lady, I would like to submit that if the leave to appeal is refused, the court can use its discretion with the applicable fairness to what it deems fair, my lady, so that what it deems fair, I can take it further than that. But because my lady, if leave is granted, my lady, the law of course must follow as fair as it can, my lady. So that's all I can say.
Thank you, Mr. Mathe. Any further submissions?
No, my lady, thank you.
Thank you very much. Thank you very much, Mr. Mathe, and thank you very much, Ms. Libber. Judgment in this matter is reserved and it will be handed down by uploading the judgment onto case lines in due course. Court is adjourned.
As it pleases the court.
Thank you.